Hello everyone, I am Sakshi Mehra and I welcome you to LexGyan's lecture series on Indian Evidence Act 1872. In this video, we shall be learning about the applicability of Indian Evidence Act, the repeal of enactment and the important definitions under the Act. Section 1 of the Indian Evidence Act talks about the application of the Act. This section provides for the applicability of the Indian Evidence Act. It specifies territories to which the Act applies and the courts and proceedings to which the law applies. The territorial limits of the Act extend to the whole of India except Jammu and Kashmir, like all other statutes, and it applies to all judicial proceedings in or before any court barring certain courts convened under certain acts. Now, let us understand what the Act does not apply. It does not apply to non-judicial proceedings, disciplinary proceedings, court-martial, affidavits, arbitrators, and tribunals. So, what exactly is judicial proceeding and non-judicial proceeding? A judicial proceeding is basically an inquiry to determine a jural relationship between either two people or a group of people or between him and the community. Whereas when that inquiry is administrative in nature, it is considered as non-judicial. For example, if there is a court case to decide about the rights of the parties, then that will be a judicial proceeding. Whereas, if it is a disciplinary inquiry, then that would come under the administrative nature and it would not be judicial. The Act does not apply to certain courts conveyed under certain acts. The Evidence Act applies to court-martials except court-martials conveyed under the Army Act, the Navy Discipline Act, the Indian Navy Discipline Act 1934 and the Air Force Act. However, the Act does apply to the native court-martial and to the proceedings before the Indian Marine Act. Affidavits. Evidence Act does not apply to affidavits even though affidavits are used as a mode of proof. The definition of evidence does not include an affidavit, and it can be included in the definition of evidence if the court has passed an order under Order 9, Rule 1 and 2 on sufficient ground. However, it is always open to the court to take into consideration all facts alleged in an affidavit if they have not been converted in a counter affidavit. Arbitrators and tribunals. The provision of Indian Evidence Act do not apply to the proceedings before an arbitrator. The arbitrators are not bound by the strict rules of evidence which apply to the court of law. And similar is the case with proceedings before tribunals. Sometimes it so happens that introduction of an act leads to repeal of enactment. Section 2 talks about such repeal of enactment. The following law shall be repealed. All rules of evidence not contained in any statute or act, all such rules that acquired force of law under Section 25 of the Indian Council Act, and the enactment mentioned in Schedule hereto, the extent specified in third column of the said schedule. Section 3 is the interpretation clause. The clause is very important as it helps us to understand the meaning and expression of the words given in the Indian Evidence Act. Court. Court includes all judges and magistrates and all persons except arbitrators who are legally authorized to take evidence. It is pertinent to note herein that this definition is limited only to the Indian Evidence Act and should not be taken in the general sense. It is also important to understand that the proceeding under the Income Tax Act are not proceeding within the meaning of judicial proceedings. Similarly, income tax officer is not a court. Administrative tribunals will not be considered as a court and inquiry commissions will not be considered as judicial proceeding. Moving on to the next definition. Fact. Fact includes anything, state of things or relation of things capable of being perceived by the senses, or any mental condition of which any person is conscious. A murdered B is a fact that is capable of being perceived by the senses, and the fact that A murdered B in self-defense is a mental condition of which any person is conscious of. Now, let us understand the difference between relevant fact and fact and issue. A relevant fact is said to be relevant to another when they both are connected with each other in any way mentioned in the act. And a fact and issue is a matter which is in dispute or which forms the subject matter of the investigation. The Indian Evidence Act is based on the basic principle wherein, in order to render a fact relevant, you must be able to fit it in the different pockets given under the Indian Evidence Act. If it can be fitted under any of the pockets given, then the fact is not only relevant but also admissible. In order to be considered as an evidence, the fact must be relevant and admissible. Therefore, it is not important that all facts might be relevant. Similarly, it is not mandatory that all facts that are relevant must be a fact in issue. However, it is the case that all facts in issue are relevant. Document. Document is any matter described or expressed on any substance by means of letters, figures, or marks which may be used for recording that matter. It includes electronic evidence and must be read in consonance with Information Technology Act 2000. Document in India includes not only the matter written but also the material on which is written. However, document in the English law is only limited to the material on which it is written. Let us now understand the meaning of evidence under the Indian Evidence Act. Under the definition of evidence, evidence is divided into oral and documentary. Oral means the statement made by the witness before a court in relation to a matter of fact under inquiry, and documentary evidence, on the other hand, is when a document is provided in support of a case of a party producing it. For example, if A claims that he is the owner of a land, then he may present a will, which would be considered as documentary evidence. Classification of evidence. Evidence may be classified into oral and documentary, real and hearsay, direct and circumstantial, substantive and corroborative, original and unoriginal, positive and negative, and prosecution and defense. We shall be discussing about them in detail in the further videos. Now, the question that comes in my mind is that what is the difference between a fact and evidence? Facts are those which are in the existence and conscious of a man. They may be positive or negative, whereas evidence is the means by which such facts are proved. And evidence may be divided into documentary and oral. It is pertinent to note that all facts are not evidence. They must be relevant in order to be admissible. Furthermore, it is also important for us to understand that evidence is the medium of proof, whereas proof itself is the result of evidence or effect. Thus, evidence and proof are not the same thing. Thereafter, moving on the definition of proved. Proved means such evidence as would induce a reasonable man to come to a conclusion. In order to decide whether a particular fact is proved, the court has to consider the matter before it and not just the evidence. This would mean that while taking a decision and deciding that the matter stands proved or a fact or a claim stands proved, the court will not only take the evidence in record but other things such as the demeanor of the witness and other such factors that may not be governed under Section 3 of the Act. Moving on to disprove. When the opposite is proved, it is known as disproved. For example, Mr. A claims that he is the son of Mr. B, and it is proved that Mr. A is not the son of Mr. B. Then the fact stands disproved. A fact will be considered not proved when it is neither proved nor disproved. Thank you for watching our videos. Please like, share and subscribe for more such videos. Also, if you have any queries, you can email us at the email ID given in the description.